decision which has been taken in context of the court, whereby Manipur High Court on Wednesday modified its 2023 order in part, whereby contentious direction was issued to the state government for considering the inclusion of Meitis in the scheduled tribes ST list. Your opening comments.
Well, I think the High Court never had the jurisdiction. This is not something to be decided by the courts as to who should be included in the scheduled tribes or scheduled caste list and who should not be included. And this will go down in the history as one of the judgments which led to the killing of so many people. It's possible that there are other factors which contributed to these killings by both sides, but the fact remains it is the judgment of the High Court which had triggered the violence. The most unfortunate part of this is that when the High Court passed this particular order, I mean, there was no reason for it because there are, up to number of judgments which in a way had elaborated the process for listing some communities into the list of the scheduled castes or scheduled tribes. As I had said many a times, that for inclusion of a community in the scheduled caste or say scheduled tribes list in this particular case, first of all, there is a need for a sociological studies whether they have the tribal traits or not. After the completion of the sociological study, then of course it goes to
So, can I take you back? Can I take you back a little, because a lot of people don't understand this issue. Why was the demand by the Meitei community to be part of the scheduled tribe list? Why did this demand come up?
Well, I mean, at the end of the day, it is a question of access to resources, jobs, employment, and reservation. So when you talk about the scheduled tribe status, of course, we are talking about the political reservation from jobs to political representation. It's access to the land and territories, because if you're a non-tribal, you cannot buy land in tribal areas. So genuinely, the Meitis have their own anguish on this issue. That's there, and it has been there, and they are not the only group. And in fact, we have to say, in many states, number of groups continue to demand scheduled tribe status. But what I was saying is that there is a process to identify, and which is laid down in the procedure itself, that the state has to conduct the sociological study, then it has to go to the Registered General of India, Registered General of India has to confirm it, then it goes to the cabinet, which forwards to the National Commission for Scheduled Tribes. National Commission for Scheduled Tribes has to approve it. Then after approval, then of course, the center, the union government has to approve it. Then after approval of the same, then the union may place an amendment of the constitution to include a particular community in the list. So where is the role of the judiciary? Judiciary has no role. Judiciary can only adjudicate whether a community has been included or not included based on the criteria of the procedures followed. So there was no case for the High Court to pass the judgment, and we have come to an extremely unfortunate situation. And I think the judges sometimes, of course, the Chief Justice of India had been categorical about it, that, High Court didn't have the jurisdiction to pass such an order. So I would say that, this was something which is uncalled for, and it's a lesson for all the judges in this country. But sometimes when you pass this kind of orders, that it can trigger absolute violence, which is, then you can blame the government.
Okay.
But there's a lesson for all of us to learn.
Okay, fair enough. Nandakumar Sharma, your opening arguments on this by the decision first.
Yeah, this order by the High Court Manipur was given on 27 March 2023. And based on this judgment, the whole crisis apparently has started. That is, the crisis started on 3rd May, whereas judgment was on 27 March. So there is a gap. So it's not exactly fallout of this judgment. And also the lawyers are highly highly educated, and they know the Constitution of India. They know who can give inclusion or removal from the list of scheduled castes. There is a let-down process, as the previous panelist has already told. There is a recommendation from the government of Manipur, then Ministry of Tribal Affairs, followed by Register, then National Commission, then Cabinet, then President signs, and the amendment. So these are the whole process. I'm sure the judge also knows it. And however, the judgment has been, presented in the eyes of the people or to the mass that High Court has given a diktat that inclusion of Meiteis in the scheduled tribe list, which is absolutely incorrect. The judges and the judiciary, they know their limitations, they know their power. And in fact, they have not given the order on their own. It is based on the petition filed by the Meitei group, so that the government process the pending this recommendation of Meitei to include in the scheduled caste. So the Manipur High Court, they have ordered to process the long pending issue of this. They can either recommend or not recommend. That's the decision of the government. So this is what. But however, it has been presented that the judiciary has been blamed for giving direction to the government or giving passing unparliamentary some sort of order, which is incorrect in my opinion. We all know that. See, the Meitis pending issue of inclusion in a scheduled tribe has to be taken up by the state government. So, but due to the pressure of the other community, the judgment has also been changed, as I have reportedly known today. And it shows that the law of the country has been under the pressure by, say, diktat of a few people. It shows the morality of the or law and order situation in the Manipur, in particular in the Manipur state. Such things should not be happening because it gives a very wrong message. If decision of a judgment can be changed under the pressure of certain community, it gives a wrong message to the whole community or to the whole of India. The judiciaries, they are highly learned, they know what is their role and their say. So it should be viewed as a judiciary being, say wrongly passed the decision or something like that. It is the
Okay.
misrepresentation of the
Okay.
order or
Okay.
decision.
Okay.
Kartikeya.
I know, Mr. Chakpa, you wanted to come in, but Dr. Tombing is also with me. Let me just take a quick reaction from him, and then I'll go to you, Mr. Tombing. Your opening comments.
Good evening, all. I hope I'm audible.
Oh yes, absolutely.
Yes, the High Court of Manipur, by striking that relevant portion of the judgment, whereby the High Court has ordered for initiating the process of ST status for the Meiteis community in Manipur, is very much in tune and in line with the established laws and principles as was envisioned in state of Maharashtra versus Milind. So in that context, my observation and then the repercussion that has happened in a sort of way, many factors taken together. Of course, the High Court judgment did spark some kind of a concern, but then we have to try to map what is this idea of being an ST and then the entitlement that is attached with it. And apparently in the Supreme Court also, there's a matter which is pending whereby the Supreme Court is looking into this aspect of what do you mean by being scheduled, you know? So it's not about class, it's about in one way a generalization, and then within that generalization there has to be some kind of other orders